Anything else other than EOTs before we go into EOTs?
Yeah, the mere mention of EOTs, I'm going to claim Wi-Fi difficulties.
What is an EOT, Howard? What does it stand
come on,
for?
thanks, Jan. Thanks for the leading question there. An employee ownership trust,
at all.
which is a specialized version of an EBT, being an employee benefit trust. And there are lots of specific rules around EBTs, and EBTs have been seen as a tax avoidance exercise, and they're not in favor with the revenue, and generally not in favor in the commercial world, because they have been attacked substantially by the revenue. EOTs are less, that's less the case as far as EOTs are concerned. And what I've been seeing in the marketplace, very relevant to our mergers and acquisitions work for Mosaic, is EOTs are being used as a friendly alternative buyer of a law firm, or in fact a family business. But I've seen it particularly in the law firm market, where you set up an EOT and the EOT buys the company from the original owner.
So what's the benefit to the buyer?
To the buyer, not a lot. Well, you've got to look at the structure. The structure is, if I'm the owner of the shares, law firm practice, and it's got to be a limited company, I sell my shares to an EOT, which I set up. I sell it in return for loan notes, and I get paid my deferred consideration out of future profits of the trading partnership. And as the seller, because it's selling to an EOT, there's no capital gains tax. So you're avoiding your 10 or 20% capital gains tax.
Which is good. And I suppose it's really a scenario where there's not an obvious third-party buyer coming in who'll pay more, or where the existing senior team don't want to do the equivalent of a management buyout.
I think that's right.
Which is the more formal way of doing it. So this is a vehicle where, if you've not got good succession in place, you can ease the succession by giving away half of it to the staff and get some buy-in.
And in fact, it's not just, you say half of it, Mark. To get the tax benefits, you've got to do at least 51%. But the norm is to sell all of it.
Yeah, have you seen people selling like 90%, so they maintain some form of...
Yeah, that's possible.
If you sell, I don't know, 80, 90%, then you keep an interest in the business, and maybe a controlling interest if you're still trying, not controlling, but a management interest if you're trying to bring the team up so they develop skills and experience to run the law firm.
I think you say controlling interest there. I think that's very important, Mark. You've got to give up, if you're the owner, the controlling interest. But there's no reason why you can't remain within the management of the limited company whilst not having a shareholding.
Mark, are you thinking of situations that may occur in smaller partnerships post-COVID that for whatever reason existing partners are unable or unwilling to carry on, and yet there wouldn't be an obvious third-party buyer, so it almost becomes a kind of job preservation scheme, almost buy your own job?
Yeah, I think that's right, because what you'd often see if a third party isn't involved, you'd see the junior partners buying out the retiring partners, or partners or shareholders in this case. And if they're not able or willing to do so, you then sort of open it up to everybody in a way and say, well, who wants to be part of this? But I think you're right. I like this phrase, Barry, sort of a job preservation scheme there.
But it's the kind of thing that you might well say. Let's say you've got a firm with, I don't know, 3 partners at the moment, and maybe 2 or 3 potential successors, but maybe 40 or 50 people in the firm. If the alternative is that the firm isn't going to be viable and there aren't any open market buyers, to actually create one of these trusts for 40 people to be part of could actually be something that is very, very beneficial, and in fact probably ought to be encouraged by the Treasury.
Well,
What
absolutely.
happens to the employees? Do they just carry on as normal?
They do, Jen, and get up to £3,600 per annum tax-free out of the employee ownership trust.
Right.
And there are some complicated rules as to how you make all of this work. Afternoon, Nigel.
Hello.
Good evening,
Hi,
all.
Nigel.
I'm sorry to be so late. My 3:30 call started at 10 to 4 and went on.
Right. Well, I've been answering most of the questions. So, Jen, yes, the employees get up to £3,600 out, but you can work it on the basis that you've got to have a defined formula for what the employees get out. And that defined formula can be linked to seniority, salary, length of service. So if you've got somebody on who's been on a salary of 100,000 a year, been there for 20 years, as opposed to somebody who's on a salary of 30,000 a year, who's only been there for 1 year, you can weight it heavily, the money you can get out heavily towards those who have been there long term and on higher salaries. However,
but the high
sorry,
is the maximum of 3.6.
The maximum tax-free is 3.6. Anything over the 3.6 then gets taxed in the normal way. Yes, absolutely.
Mark, just sort of changing tack slightly, have you any sense of what kind of view the SRA would take of firms going down this route? Presumably, if the alternative was intervention, they'd probably have quite a benign view of it.
Absolutely. I mean, the SRA, just remember, what they're interested in is client confidentiality, client service, and protection of client money. And as long as you can show them that you've got a good management in place and the systems and controls, they're not going to be too worried. And as long as, I mean, interesting point, I suppose, thinking about it, is if you open it up to all the fee earners and they're all solicitors, you're going to be fine. If you opened it up to the whole staff to include accountants and secretaries, you presumably, I'm looking at Howard here, would need to register the thing as an ABS.
Probably. And in fact, you've got to include all employees.
So okay, thinking aloud then, I've read of firms doing this. I've not done one. You'd need to set up an ABS.
Yes. And if you're a partnership, you've got to convert to a limited company at the time you do it. And whilst that's quite the norm to do this, it is sensible, highly advisable to actually get a tax clearance that the conversion to a limited company and then the subsequent sale to an EOT is actually treated as a capital transaction and doesn't fall foul of some of the nasty anti-avoidance rules.
So it's quite complicated then.
Hi everyone, well I'm sorry to interrupt part one of our coffee breaks on EOTs, but due to length of time we've decided to break into two sessions, so this is the end of part one. Watch out for part two, coming to a LinkedIn post near you soon. Bye.